Commit everything you do to the Lord. Trust Him, and He will help you. He will make your innocence radiate like the dawn, and the justice of your cause will shine like the noonday sun. Psalms 37, 5 through 6. Hello, my name is Stephanie Davis. I'm a child of the Most High God, First Lady of G&J's House of Prayer, published author, member of the NAACP Tulsa Branch 6143, and wife and advocate / warrior for Jeffrey Davis, pastor of G&J's House of Prayer and wrongfully convicted hostage of the state of Oklahoma. You may think these are harsh words or I'm being overly dramatic. However, after you hear his story, I believe you'll agree with me. I want to share with you some of the fight for his freedom. First, I will share the crime he is convicted of so you will have some background to start with. All the information is pulled from court papers and conversation with Jeffrey Davis. I'll be sharing some of the documents with you to allow you to see with your own eyes and not rely on my words alone. Feel free to stop the video in order to read for yourself. August 13, 1991, Jeffrey Davis had given his uncle a ride home along with his uncle's friend. Although he had planned to just drop them off in Apache Manor and leave, Jeffrey decided to hang out and visit some family and friends who were out in the crowd. After a bit, a car pulled into the apartment complex to buy crack. It had 3 men in it: Raymond Leon Broomhall Jr., the driver, John Clayton Johnson, the backseat passenger, and Richard Hicks, the front seat passenger. As it came to a stop, it was surrounded by the drug dealers trying to make a sale. Jeffrey did not deal drugs. Anyone can see from his juvenile record and previous arrests, none of them were for drugs. He continued to watch and visit with others in the crowd. According to the then 16-year-old John Johnson, he had been drinking with Raymond Broomhall and Richard Hicks. After that, they had drank at least a 6-pack of beer each. Raymond had wanted to go buy some crack. As they pulled into Apache Manor, one individual approached the passenger side after Richard Hicks called him over. Almost immediately afterwards, approximately 10 to 15 individuals surrounded their car. He could not recognize anyone because it was so dark out, but one of them had a gun held to Raymond's head. The gunman told Raymond to give him his wallet, and Raymond told him no. A second man hit Raymond in the left side of the head, touching the car door as he did. At that point, John Johnson got into the floorboard and they took off. As they were taking off, he heard gunshots. Richard Hicks would go on to say that Raymond Broomhall was approached first on the driver's side. He believed there to be at least 5 people that approached the car as the gunman demanded Raymond's wallet. He could not identify any of them as it was too dark. He too would say the gunman began to shoot as they were driving away. They made a few blocks down the road before Raymond would die from a gunshot wound. He was hit in his back on the right upper shoulder area. The bullet passed through his heart and came to rest down toward his left chest wall. It would appear the shot came in from the passenger side of the car. Back in Apache Manor, the crowd had regrouped and continued to visit and hang out. A copper 76 Ford Granada would pull in. The driver, Richard Lee Fogelman, was looking to buy some drugs. After making his purchase, he saw 3 men approach from the rear of the car. They made their way to the driver's side. He identified Monroe Alexander as the man who placed the gun in his ear and demanded his money as he cocked the gun. The other 2 men would stand back according to Fogelman, and the man he identified as Grayson would be encouraging Monroe Alexander to shoot. The third man, identified as Jeffrey Davis by Fogelman, stood in the back and did not say or do anything. As he heard the gun cock, Fogelman immediately pushed the barrel down and was shot in the chest. He stepped on the gas and got out of there right away. There was only one gunman, and he had shot him. In the 10 to 15 seconds from beginning to end, Fogelman would have us believe he correctly identified 3 young black men in the dark with no moon and minimal streetlights. He can remember their faces, but not what they wore. That is not even considering the extreme stress of being robbed and shot or having done crack earlier in the evening. The following day at around 4:40 in the afternoon, Jeffrey Davis was out riding with his brother and some others when the police pulled up behind them. His brother tried to get him to run, but he felt confident everything would be okay. because he knew he had not been in any trouble. He allowed the police to arrest him. They brought him in on a 2-month-old trespassing warrant, and he sat there thinking he would get bonded out and be back home soon. That all changed when Ham and Chiefy stopped by, banging on the bars of his cell and laughing, telling him it had to be a Davis boy to kill a white boy at Apache. These two officers had harassed him and his family for years. Police brutality and crooked cops are nothing new. These two had it out for him. He didn't know their real names, only the names that they called them on the streets. But he knew their character. They had beaten him, his brothers, and family, and stole their money many times. They would drive them around in the back of their patrol cars through the neighborhoods to make it look as though they were snitching. When he was 16, they had told him when he turned 18, they were taking him off the streets for good. Now he wondered what they were planning. This was the first hint he had that things had taken a turn for the worse. The homicide detective would testify that Jeffrey requested to speak to him that night and said it was recorded. However, instead of presenting this recording in the court, the homicide detective spoke on what Jeffrey basically said, not on his actual words. In fact, the detective was caught by Jeffrey's attorney lying and misleading the court about what was said on at least one occasion. Jeffrey has no recollection of this meeting and interview and has repeatedly said that it makes no sense that a person brought in on a trespassing warrant, which he could have bonded out on, would request to voluntarily tell police he was involved in a robbery and homicide. Given that Jeffrey had dealings with the police throughout his teen years, he did not look at them as friends or people to be trusted. They brought him before the judge, represented by a public defender, on August 21st, 1991, barely a week after bringing him in on a trespassing warrant. They charged him with count 1, murder in the first degree, count 2, attempted robbery with a firearm, count 3, shooting with intent to kill, count 4 and 5 would come later. They set his bond at $1 million for the murder charge and $50,000 on each of the other charges. August 27, 1991, they would add count 4, robbery with firearm, and count 5, shooting with intent to kill. His first public defender, Ollie Gresham, dismissed himself from the case during the pretrial stage, telling Jeffrey and his dad that they were planning to railroad Jeffrey and he wanted no part of it. Jeffrey returned to court and was met by Edward Glass, who told Jeffrey he was his new attorney. Mr. Glass was not retained by Jeffrey, nor his family, and there is no indication in the record whether Mr. Glass replaced Mr. Gresham as appointed counsel. Jeffrey's attorney he hired in 2017 found that Edward Glass was not licensed to practice law in the state of Oklahoma at the time he entered an appearance and conducted the preliminary hearing. An unlicensed attorney violates Oklahoma law when they represent to the court and to their client that they are otherwise licensed to practice. Additionally, he neglected his duty to consult with Jeffrey during all stages of the proceedings and neglected his duty to investigate methods for impeaching prosecution witnesses. These and other errors, I will cover in future videos, left Jeffrey with no confidence in this attorney. He made many requests to the court to terminate Edward Glass, but was denied this request. Jeffrey went so far as to file complaints to the Bar Association in attempts to acquire a new attorney. They in turn suggested he request this of the judge in the case. This again was denied. The tensions between Jeffrey and his attorney, we believe, had a negative effect on his attorney's performance in his defense. This goes against his Sixth Amendment right. His attorney suggested a trial by judge and told Jeffrey if he was to go to jury, he would be a young black gangster tried by a group of white people and would be found guilty for sure. After he signed the waiver of trial by jury, the prosecutor told his dad that they had him now. He said he didn't have anything to tie him to it for sure, but now that it was trial by judge, they had him. The judge found Jeffrey guilty on all 5 counts and gave him 50 years on each, running consecutively. The judge asked the bailiff how much change he had in his pocket, and he had $2.50, so he said that was the sentence, 250 years. Section 1363 of Oklahoma Title 22 reads as follows. It shall be the responsibility of the trial counsel to file all jurisdictional documents required to be filed in the district court and the Court of Criminal Appeals to initiate the appeal. Jeffrey's attorney, Edward Glass, failed to file a notice of intent to appeal within the requisite time period. Additionally, trial counsel failed to file a certification of advice of appeal rights. In fact, the record is completely devoid of any filing, pleading, docket entry, and or notice from trial counsel after Jeffrey Davis was sentenced by the district court. Simply put, it appears that trial counsel disappeared from the petitioner's matter after the sentencing occurred. Further, at the time that Jeffrey Davis's time for initiating a direct appeal had expired, trial counsel had not filed a motion to withdraw and or requested to be relieved of his statutory duty to initiate a direct appeal. Given the failure of trial counsel to file either an appeal, a certification of advice of appeal rights indicating Jeffrey Davis did not wish to appeal, or a request to be relieved of his duties through a successful withdrawal, Jeffrey Davis had every right to expect that his trial counsel would follow his instructions and statutory duties in perfecting a direct appeal. Trial counsel's failure to do so was a direct violation of Jeffrey Davis's right to effective assistance of counsel. Remember, Jeffrey was barely 18 when he was arrested and had a 9th grade education. He had no knowledge of the judicial system or how it worked. Jeffrey had requested and was granted a 10-day stay after sentencing in order to appeal, but his attorney never returned. Disregarding the judge's orders, they shipped him out in 5 days. Upon arrival at the prison, he began to talk with the other men there about an appeal. Because of his attorney's failure to represent him effectively, it was beyond the time to file the appeal. He began to request copies of the trial transcripts to access the courts for an appeal. Jeffrey Davis was sentenced on 4/8 of 93. He requested a copy of his trial transcripts on 5/6/93, 5/21/93, and 8/19/94, and was denied on all 3 attempts. Under the 14th Amendment of the United States Constitution, equal protection requires the state to provide indigent defendants with the basic tools of an adequate defense, including trial transcripts, when those tools are available to other defendants for a price. The denials made by the same district court judge that convicted Jeffrey were insufficient and made no reasonable determination why Jeffrey had no need for his transcripts. Oklahoma Statutes Title 20, Chapter 15, Destruction of Court Records, Section 1005, allows the destruction of felony records of adjudicated cases after a 10-year period has elapsed since any pleading has been filed or any action taken in the case. There was never that long of a period that Jeffrey did not fight for his freedom. After continuing to pursue his innocence with pleadings and actions being taken on his case in 93, 94, 95, 96, 2001, 2002, 2003, 2004, 2006, 2012, 2013, and 2016, it was discovered the trial transcript had in fact been destroyed by the state and never transcribed. In response to Jeffrey's statement in his 8th PCR that the only witness against him had perjured himself on the stand at his trial, the state responded in a footnote of the response, quote, "The exact testimony is unknown. The state has contacted the court reporter Joanna Smith to obtain a copy of the trial transcripts. Ms. Smith advised that her notes had been destroyed while in storage and she had no way of transcribing the testimony." They had everything in Jeffrey Davis's case transcribed and saved in the archives leading up to his actual trial, as well as his judgment and sentencing and everything afterwards. Why was his actual trial the only thing destroyed and not transcribed? Why did his request for transcripts, as well as his first 3 post-conviction applications, go to the judge who convicted him only to be denied? To me, that seems like a conflict of interest. If I had convicted a person as a judge, I would be less inclined to admit I have made a mistake. They should have an independent entity to look into the wrongful conviction claims, not the same judges who are employed with the ones who convicted them. Jeffrey has been barred by the state from any further filing, even though he has been denied his rights and has proof of his innocence, including an affidavit from the only person who did testify against him, stating Jeffrey had taken no part in the crime at all. The court accepted perjured testimony that contradicted the victim's testimony, with no corroborating evidence or testimony. The courts exchanged leniency and dropped charges in exchange for testimony against Jeffrey. This conduct is not legal and should never be allowed to happen. They should not be able to throw out claims of innocence when there is evidence of a wrongful conviction. The laws need to change so that innocent people are not held hostage with no way to be heard. Their pleas for help and justice should not be going back into the same crooked system that put them in the situation they are in. We have to do better. No one should be stolen from their life and locked away when they are innocent. Time cannot be returned once it is taken. Jeffrey Davis has refused to give up on life, even though he has been incarcerated all these years. He has given his heart to God and pastored the church on the inside. His heart is to show other men that there is hope in Christ. You can be free even behind bars when you have Jesus in your heart. He will continue to minister when he comes home and help reach others who are in the same situation he was in. Jeffrey and his family are asking for help and direction at this point. Where do we go from here to seek the justice he deserves? He has been denied his rights and deserves to be heard. We appreciate any advice and help on this journey that you can provide. Please share this and get his story out to the world. There are so many people with similar stories I have heard over the years. Our justice system seems to be about winning a case and not about justice at all. We have a petition on change.org called Free Jeffrey Davis. Acknowledge his proof of innocence. Please take time to read it and sign it and share it. Encourage others to do so as well. Share this video with everyone you can. If you have any advice or questions or know anyone who might be able to help, please contact me by email at stephdavis1332@yahoo.com. Thank you and God bless you.